Diana, let me just set the ground rules here a little bit so we can understand each other better. I've not interacted with you before, so I have no basis to presume any intention on your part, particularly. However, the particular VGSO official that's in charge of this case, Ms. Carol Orfanos, I unfortunately now have a history with her. I'm actually making very serious allegations against her in some of the proceedings. I'm seeking declaratory relief against her for essentially perversion of the course of justice and declaration that her conduct has been in breach of Section 4 of the IBAC Act, which is the corrupt conduct provisions. Well, a provision of the act that deals with corrupt conduct. And I'm also in the process of issuing concerns notices to her in relation to defamation proceedings that I've instructed people to commence against her imminently. It's just the volume of work that we're dealing with, which is taking its time. The allegations made against her are on the basis that in one of the proceedings that she's responsible for all the prosecutions that are currently against me. I mean, I think the state started with a dozen or so. Around 8 proceedings have been withdrawn by the prosecution. There's a few more that are left. In another matter where it was alleged that I had resisted arrest, again under Ms. Orfanos currently, the indictable charges were recently withdrawn at the committal hearing, the day before the committal hearing. And it's a case where there's been extensive tampering of the CCTV footage from VCAT. The prison records have been amended. And we know that this has happened because the body cam footage from one of the two...
I just want to stay focused on this.
No, we are staying focused on this. I'm saying you're instructed by a solicitor who I'm saying is implicated in the commission of those offenses. And it's not just one proceeding. In 3 or 4 proceedings, she's doctored, or under her case management, the prosecution has doctored video footage. She's just admitted to that in another proceeding. And in this particular proceeding, it is alleged that I am responsible for someone getting hurt in an incident where there was an eyewitness. The eyewitness has never been spoken to. Mr. Alan McGregor, when he gave his statement, said there was an eyewitness. The incident took place in an office which is heavily surveilled, famously and notoriously surveilled.
Inside the office, or do you mean
inside the office? It took place inside the office. He was an employee of a company that I own. I have footage of the incident, audio recording of the incident, rather. And it captures exactly what happened. This is a frivolous matter. Yes, this is a completely facetious proceeding, which Ms. Orfanos has instituted as part of her, corrupt agenda. I have a recording of the incident. There's eyewitness footage. Mr. Alan McGregor is sadly demented on account of his age and other issues. There's a medical document that his general practitioner has issued.
I've heard about that one.
The LSBC auditor determined that he was clearly demented during the last audit. And just after the alleged incident, there was a disciplinary meeting at the firm between the director of the firm responsible for human resources in Alan and the eyewitness, in which an extensive record was taken of the incident. Mr. McGregor sounded like he was completely incapable of remembering what had exactly happened. He gets lost. The prosecution is responsible to get certification before they prosecute cases of this sort.
What do you mean certification?
Of his mental health, so that it can be determined.
His capacity to
give
remember.
evidence.
Is that what you mean?
To give evidence under the Evidence Act, his testimony is inadmissible. I think it's pursuant to section.
I know the section you mean. There's a competence provision in there.
Yes, that's right. So in any event, I have evidence of the incident. I have a recording of the incident, which, by the way, we're using to go after him pursuant to the Corporations Act. But the simple fact is that the only relevance of this proceeding is that it shows Ms. Orfanos's ability to pervert the course of justice. If you continue with this proceeding, I will add you to the claims that I bring against her.
I'm sure you don't mean that as a threat.
No, I mean that as a warning. And that's why I told you about the
background.
The background. Because
Well, I'll just...
let me just clarify. Let me clarify one thing. I don't have time to issue threats.
This has to be a conversation too between the two of us. So
Willingly, yes.
It's an opportunity for you and I to speak. But I
We're
just
both here
want to know
willingly.
that
We're both here willingly, and I'm pressed for a time.
you're talking over top of me. Yep.
Yeah, that's fine. I'm comfortable with that. I'm being persecuted by the state. I think I have a right to be shot. I have given you the background.
Yes, yeah.
And let me just complete. What I'm saying is that I'd like you to do your own research. Most of the people that Ms. Orfanos has brought in proceedings before have been people that had a flexible, ethical conscience. And unfortunately, again, I understand that before a person gets a brief, they don't actually know the case, and a barrister is obliged to take every brief that they get. I appreciate that, and I deal with it in that good faith. We are going to write to all the barristers shortly. We have accumulated the email addresses of everybody on the Vic Bar portal to make them aware of what Ms. Orfanos is doing. And
can I just check, are you represented by a legal practitioner?
I have a law firm that I own, which... so I have a infrastructure that supports me. Right now, that's...
I just want to be absolutely clear, because if you are
I'm not
legally
represented in the sense of the proceeding, though.
Okay. Otherwise, I don't need to speak to that person.
No. I don't trust other people with speaking on my behalf. So, anyway, the crux of the matter is that I don't hold it against anybody that they take a case, but I will expect them to do everything that they should do in terms of upholding the law. And I think it's absolutely peculiar that this is the, I think, fourth or fifth proceeding in which Ms. Orfanos is involved with in prosecuting me, where she's only gotten involved after a number of red flags have been raised. I understand her agenda to be mitigating the state's liability, because I'm in the process of bringing malicious prosecution proceedings for damages against the state after I get the matters dismissed. So the VGSO's interest in all of this is to mitigate the amount of damages that I get. And in I don't think it's necessarily personal. I just think they are conducting their business in a manner that's not ethical. And
so can you put down the form that we need to complete for the summary case conference process? It's a very simple form prescribed.
I'm aware of that.
Yeah.
So this proceeding is also subject to a judicial review action. I'm not sure if you've been told that. So I've already commenced a judicial review proceeding in the Supreme Court in relation to matters concerning... So I was arrested on the 20th of July, allegedly for the a purpose of being interviewed for this proceeding, but it was actually in connection with something else. In that proceeding, I had started a in relation to that proceeding, I had started a judicial review proceeding. I am adding the remaining aspects of this proceeding to that judicial review proceeding. So when that proceeding was started, I wasn't aware of the charges that were brought in this, although I had suspected that, and also I had been informed that the state was going to bring charges in respect of this proceeding. So I have already made an application for the relevant people in connection with this proceeding to be added on to that judicial review proceeding. So at the next hearing, the informant in this proceeding will be added on, and I think Ms. Orfanos is already a defendant in that judicial review proceeding, but in any event, there will be further claims brought against her in relation to this proceeding, absorbed in the judicial review proceeding. I can give you the proceeding number for that. It's SECI.
Yes, you like.
SECI 2023 00183. Sorry, let me just confirm. No, that's for a different judicial review proceeding, also against Ms. Orfanos, but this one is SE. So it's SECI 2022 04527.
Sorry, 04.
527. It was started in November last year, so 2022. It's a proceeding that stems from events concerning my arrest on the 20th of July, which purportedly was in connection with Alan, but, was actually about something else.
I'll definitely, in terms of the issues that you've identified, the one that we've discussed in depth so far is prosecutorial misconduct. That's probably a heading that describes it. The court will also want to know the factual dispute that exists. So, for example,
so there's dementia. The main issue is dementia. So I think Alan is confused about what has happened, and he has been partly misled, but he's also partly I don't want to misattribute any ill intention to him necessarily, because I don't know what is driving him, but I have gone through the recordings of his internal discussions with Maria after the event to take his complaint down, and he was completely...
She's the HR person, isn't she?
Director of HR.
Yeah.
And she went through a director's meeting. But now, to give you some idea, Alan...
I just want to come... I've got certainly prosecutorial misconduct. Confidence is a big issue that you've spoken to.
Yeah, but also you need to understand this. Alan was visiting porn sites at the office while he was working there. This was discussed during the meeting. And he was basically, I think, incapable of appreciating that he was working in an open space office a lot of the times, and other people could see his screen. He had a bodily...
Is this on the 11th of October, or is this a different meeting?
So on the 11th of October, 11th of October is when the incident took place. This was on the 3rd of November after the incident. But on the 11th of October, to give you some context, what happened is Alan showed up at the office in trousers that were soaked in urine. And he was in no condition to attend a hearing. He was there to attend a hearing, and I thought we would be in contempt of court if Alan attended the hearing. So I asked him to go home because he was not clearly well. The thing about him, and we were very good friends, so this sort of bothers me personally, but the moment he felt that his capacity was being challenged, which I understand is a common occurrence with people in that demented state, he would get very defensive and aggressive. So when he was asked to go home, he felt that it was his capacity to work was being challenged, and he became very aggressive. So he was then asked to leave the office, and it was done in the context of the hearing starting in 5 minutes. In fact, at one point the associate was told that we would take a few minutes to come on board, and the judge was waiting for us. When he was not leaving, he was told that he was trespassing. Somehow, so the hearing was to be attended from my personal office, and then there was an open space office. He managed to get out of my office and go and sit in the open space office. Now, what we were concerned about was that he would barge in the middle of the hearing, in that state that he was in. He was completely disoriented, and he had gunk on his face. His hair was, and he was very shabbily dressed. So Lulu, who the eyewitness was, asked him to leave, and he just wouldn't leave. And then he started to make his way into my office. Lulu acted as a physical barrier. So the door was open, and when he started moving in, Lulu basically stood at the doorway. Somehow, Alan managed to, go under her arm and get into the room, and then Lulu was actively blocking him. At one point in time, he pushed against Lulu, and then fell onto the sofa. And it was the armrest of the sofa that I'm told that he hit his ribs on. Now, I wasn't looking at him at the time because I was too busy behind my desk packing up my stuff to go to the other office so I could lock the door and attend the hearing from there. And the only reason why the camera recording was off that day in that room was because we were to attend a hearing, and we typically turn the camera off because it has both audio and visual thing. My devices are always on recording, and when I attend a WebEx or other thing, then I get prompted to, I get asked whether I want to continue with it or not, and that's how I make sure that I'm not, inadvertently recording hearings and so on. So the cameras were, but because my devices were on, so long as I was in the room, the whole incident was captured. It clearly captures that I was nowhere close to Mr. McGregor. I didn't even know about the. Plus, he didn't make any explicit. After going through the recording repeatedly, I've identified one part where there's a slight groan of sorts where one may think that there's been some cause of inconvenience, but there was no act. Like, he stood up, he kept fighting. By the way, the recording starts with him saying, this is before even he was asked to leave, but clearly shows his state of mind. It starts with saying, you need to get Lulu out of here. He shouts, he says, you get her out of here. I don't want any witnesses.
So I've also identified that the issues are effectively whether you physically made contact with him.
No, I did not.
And a causation issue. So to the extent that he didn't have an injury, that was because he's fallen when he's
he's saying he had an injury.
Lulu.
He's saying he's had an injury. We do not know whether. I've really tried hard to identify in the recording whether or not the injury took place at the office. The most I can do, and again, this is me working with the presumption that he must have had an injury, and then listening to the recording, and then I can barely hear, some groan, which is part of the regular grunts and groans that old people have, and now I have because of the hours that I'm working. So, he's just upset. He's very, again, I don't want to misrepresent things. Alan was a dear friend when he was in the right state. But suddenly he would snap and say, are you a fucking faggot? Why are you following me? As we're going to places together.
I might just pause to talk about the recording.
No, let me just complete this. I think you're... so I don't get the impression...
I need to help. This needs to be a bit of a discussion.
Yeah, but you can ask me... So when you want to tell me something...
I'd like to ask you a question just at the moment here.
But not in the middle of interrupting me, so I don't get the impression that you were trying to block information away.
Well, this is just a summary case conference of two people talking to each other.
Yes, but you also have obligations to not continue with the case if you know certain things. And I just want you have an obligation to not continue with the case if you know certain things, and I want to make sure that I tell you all those things.
Well, I do have questions though, and if I don't get an opportunity
after I'm done, which will not be very long, you can ask me any question you have.
I just must say we've only got until about 2:40 for the league.
I will be done within 7 minutes, so you will have 10 minutes to ask the questions. So, again, this was a man who would suddenly snap in the middle of things. He once shot himself during a hearing, and that was the subject of considerable judicial... So, he was attending a hearing, he was waiting for the judge. The moment the judge came on, he had an accident for which he had to rush to the washroom facility without even being in a position to tell the judge. He had defecated on himself. The judge was then furious because it looked like he ran away as soon as the judge came on. Again, the whole incident was recorded because it was in the office, not on camera, but through other means, and there was an extensive report done about this. There were a number of conversations that were all recorded contemporaneous. He apologized to the judge, said he had a medical issue at that hearing. The judge was livid because he had to wait for half an hour for the hearing to resume.
And how does that connect to this case? What's the connection?
It was immediately before the case. That was the mental state that he was in.
On that day, on the 11th?
No, in the days preceding that case. We're not even talking about a 1 month difference. And he was showing up in soiled trousers every day, mentally disoriented. He was being contacted by the LSPC and there were conspiracy theories put in his head on top of that. We have evidence of that. He was expected to leak client files, which he did. They were made part of the report. There are allegations. So, to give you some context, the other proceeding in which the indictable charges were dropped, it is claimed by the auditor that Alan told him that I had assaulted the PSO. There is no allegation that I had assaulted the PSO made by the prosecution in that case. The allegation was that I had resisted arrest. I had not resisted arrest. There was no power of arrest. I had thoroughly reviewed the legislation before that altercation. And it was a whole bunch of things. The charges were dropped. Now, the summary offense charge, which persists, is head by Ms. O'Connor. I'm not done with the 10 minutes yet. If I may just complete, it'll make sense at the end of it.
Mr. Foxall, I've been very patient in listening to you, and I do want to, but...
I think you're trying to avoid information. What
information?
That may not be convenient to your ability to continue with the case without being sued, but that's fine.
Mr. Foxall, I just have questions that I'd like to ask.
And we had agreed that you would start asking them from 10 to 2:30 onwards.
You set down.
And you agreed.
You set that rule.
Okay. No, I think it's a matter of uncontestable record that there was an implicit agreement in the fact that you did not object to it at the time, and then we continued with the matter.
Okay, then we've got 3 minutes.
Well, you interrupted me for another minute, so I'll take until 2:11. So the fact is that Ms. Orfanos, in that particular proceeding, in relation to which we will write to every barrister in the state shortly, the summary charges that are being pursued arise out of a breach of the Court Security Act, which does not give rise to a power of arrest, and everybody knew about that. In the Victoria Police when I say everybody, I mean the officers that brought the charges. There's communication that has been discovered between the officers that there was no power of arrest and they were still pursuing those charges. The reason I talk about that proceeding in relation to this one is that on the 28th of February, when evidence was discovered to me from the body cam footage, for the first time I saw that the police had initially contemplated pursuing an allegation that I had assaulted the PSO. I did not know about it because this was done in private communication, not in front of me. The charges were never brought. The allegation was never introduced in the proceeding. I only discovered this on the 28th of February this year. However, last year, or the year before last year, actually in 2021, in December or November 2021, the auditor, Nailon, of the firm that I own, said that Alan had told him that I had assaulted Victoria Police. Now, I had access to all the communication that went to Alan. Victoria Police had not told Alan that I had assaulted him, the PSO in question. So, Nailon was told this by Victoria Police. He then used Alan's dementia to attribute the allegation to Alan. This was in a published report of Nailon. In any event, he had no business talking to and then publishing about an active case file that Alan was maintaining in a criminal proceeding. And ironically, while he's saying that he suspects Alan has no capacity and is demented and loses his chain of thought, he also clarifies that Alan has waived client legal privilege. By the way, it's not his privilege to waive. It's the client's privilege. And that's why he can write about those things. So we're going to write to every barrister in the state about this matter. Communication is being drafted as we speak. It will go out before the next hearing in this proceeding. We'll write to every media agency. We're just preparing all the communication in a meticulous way so we can bring out the criminality of the actions. The record of when I was at the police station has been doctored. So the body cam footage of the officers that were in attendance at VCAT shows that they arrived at 4:30. They also swore affidavits to that effect. 2 officers. Then 4 officers swore affidavits that those officers that had sworn affidavit that they arrived at 4:30, they had in fact arrived at 3:30. That's the evidence of 4 officers. And the body cam footage shows that I left VCAT building at approximately 6 p.m. The records from the station, police station, where I went where I was taken after I left VCAT building, show that I arrived at the station at 5:10 p.m. or 5:13 p.m. So approximately 40 minutes before I had left, as per the body cam footage. All of this is done to minimize the time or minimize the record of the time that the PSOs were strangling me, literally choking me, so they could get me to put the handcuffs on, let them put the handcuffs on. And that footage has been doctored. There's footage from the VCAT CCTV cameras that are internally inconsistent with each other in terms of the time they show that different events are taking place. So I'm going to make sure that every barrister knows about this personally, and the fact that Orphanos is continuing with this case after 2 OPPs left the case, and the 3rd one dropped the charges, and then Mr. Orphanos continues with the prosecution where the legislation does not permit it. And I know that some of the barristers get the cases without knowing what the content of the brief is. And so if I have to hire people to personally knock on every door, to make the citizens of the state aware of what's going on, I will do that. But anyway, I'm done. I can answer any questions you have.
Thank you. I've taken some careful notes so I can remember the substance.
Please convey this to her as well. This is, well, it's not official thing. We will write to her half a day before we send out the communication to everybody. But it will be in the next 24 hours, so she'll get a little bit more warning this way.
So in terms of the things we can, or the one matter that I just wanted to speak and raise with you, and it is, of course, one of those fundamental rules in any criminal proceedings is that the prosecution has the burden of proof. And so there is absolutely no obligation on an accused person to themselves prove their innocence.
I know.
And so one of the things you mentioned,
I've become sort of an expert on these things.
Yeah. And you mentioned that you've kind of got recordings and videos, and you are under no obligation.
And that's why I have not produced them. But I had advertised this right from the beginning. No one came to ask for them. And that's what I'm proving through this conversation, that you're not making a proactive. By the way, why did no one speak with Lulu?
So what I was just meaning to say, sometimes in case conferences,
I'm not going to give you the. No, you need to speak with Lulu. I will give you the recording when I give it to everybody else and tell them about Orphanos. But sorry, I can't see you, Diana. Your video has gone out. Diana, your video has gone out. Everybody else is here. I can see VGS or paralegals. Fine. Admin is okay. It's only your connection, I think, that is problematic, Diana. Diana, I see your connection has been restored. I'm being asked to mute myself. Now, Diana has left.